Hello, everybody. Welcome to another edition of The Productive Attorney. My name is Jim Zeta. I'll be your host. This is a podcast where we talk about things that can make you more productive so you can do the things outside of work and outside of practicing law that make you happy. Today, we're going to talk about judges. We're going to talk about experiences and tips that I have after 33 years of being an attorney and appearing in front of judges. And we're going to talk about some examples of judges behaving badly. And some judges have behaved very badly. For those of you watching the video, I'm wearing a shirt, Fort Worth Vaqueros shirt. Fort Worth Vaqueros is a local semi-pro soccer team that we have sponsored since its beginning. I think it's 7 or 8 years now. And I really like this particular shirt. It's very busy, but I like it. So part of the reason why I'm doing this podcast is because my son, Michael, is going to be going to law school, and one of his stated reasons for going to law school is he wants to be a judge. And we talked about how he can become a judge and the pros and cons of becoming a judge, and we just talked about that today, as a matter of fact, and so it was kind of fresh in my mind. When I started out at Shannon Gracie, there was a judge, Judge Murray. He was a judge from the 17th District Court, and the law firm I started with Shannon Gracie hired him after he came off the bench to mentor young lawyers. And Judge Murray was one of the kindest, nicest people I've ever met. And I would go into his office, and I remember going into his office and telling him, "Hey, Judge, here's the motion, and here's the argument I'm going to make." And he was very nice to me, and he looked at me and he said, "Jim, I think you need to come up with another argument." Because I clearly wasn't going to win. But it was so valuable having for him. And when he passed away, his wife was so kind, and she gave me one of his shirts that I actually still have. And so my first experience with dealing with a judge inside a firm was very positive, and he was a great guy. What I have found is that judges, during my lifetime, judges have been, obviously the ones I deal with are elected in the local and the Texas elections, and in the federal they are appointed for life if they're federal district court judges or courts of appeals. And what I have found is that judges generally stay away from politics, and they've been easier to stay away from politics. Lately, there's been school boards that have been gotten involved in politics, and just about every other elected official or appointed official has seemed to have gotten heavily into politics. But my experience is that the judges that I've dealt with locally in the state of Texas stay away from that pretty well. There was a time back in the 90s when the judges here in Tarrant County, the county that I practice in, when they all switched from Democrat to Republican, when they realized that the Republicans were the winning party, and they have to run in one party or the other. These judges weren't really Democrats or Republicans when they were on the bench. They were just judges trying to... Sorry, I had to drink something. Judges trying to make a living. And so it was that to me is indicative of how they don't get into politics. But one thing that does happen with most judges that I have seen is they get what me and my friends call judgeitis. And that is, they'll get on the bench, and they'll typically be on a bench for 6 months to a year, and they start to believe that they're, better. Their jokes are funnier. Their calls get answered quicker. They get called Your Honor all day. And it just is human nature with additional power and additional compliments that the person begins to think that they're better. And it's not necessarily that this feeling is, I don't even say it's a negative. A lot of times when judges have that kind of power, they have to keep their impartiality, and it kind of reminds them that, okay, I can be, light with the people that come in my courtroom or be cordial with them, but I do have to keep a sense of decorum. But it's interesting to see people that who have become judges, and some change and others don't. But you just have to kind of watch that, especially if it's somebody that you know. So I have some specific tips on dealing with judges, and specifically with how to do it when you have a hearing, you have a trial. How is it that you deal with a judge? The first thing is, if you have a hearing, I always say go early. And the reason why I say go early is, number one, you don't want to ever keep a judge waiting. That is a cardinal sin. I was at a hearing one time when a lady came in and said, "Sorry, Judge, I came from Dallas and the traffic was terrible." She was about 20 minutes late. The judge was clearly irritated. Maybe she'd been late before because this judge doesn't get that irritated. And not but 20 minutes later, a lawyer comes in early for his hearing, and the judge says, "Hey, Mr. Smith, thanks for coming. How was the trip from Dallas?" So exact same route. And he said, "Your Honor, smooth sailing." And that girl went white as a sheet, which goes to, well, that's one of the things that I tell you to go early. The other reason I tell you to go early is because you want to see what kind of mood the judge is in, how the judge is ruling that day, whether the judge is behind on their docket, how they're pushing people along if they're behind on their docket, whether they're asking questions that day or not asking questions that day. Just any tips you can get by getting there early and get a real sense for the judge, what she or he is feeling that day, is super important for you when you go up to argue a hearing. Once you're there and you're actually up doing the hearing, you need to know how much time you have. And by going early, you can kind of figure out where you are in the docket. Also, you make sure you go up to the bailiff, see if there's anybody else that has hearings at the same time that you do, see what kind of hearings are going on, just get a real feel for the courtroom, and then sit in front and sit quietly. Don't look at, be on your phone the whole time or rustling papers the whole time. You are there, you are quiet, and you're just waiting for your turn to have the opportunity to argue your case in front of that judge. Nothing else should distract you. Don't get your phone out. Don't be texting or doing other stuff. Just sit there, pay attention. Nothing is more important than why you're here and why you've got that hearing coming up. Once you actually are up there and doing your argument, different people do it different ways in terms of how they prepare. I like to have an outline of my argument before I go in, but I have it in broad enough terms and gone over it enough that I sometimes just highlight really key words in it so that I can glance down and look back up. I think judges respond better when you are natural to them and you're having a conversation with them. And also, if you're not down looking at your notes, you're looking at the judge and seeing if the judge, he or she, is bored, if you need to move on to the next topic. Some judges signal that, okay, I'm done with this argument, you need to go on. I know a judge that'll take a sip of coffee. And that's kind of, it's not, he never told me that, but that's to my signal, like, okay, he's done with this particular argument. He wants me to move on. And so you can kind of tell. And the other thing I would give a piece of advice for is you never know whether a judge has read your brief or not. Most of the time we will spend hours, sometimes days, preparing our brief. And so there's a couple ways you can do that. But the way I typically do it is, well, good judges will come in and they will tell you, I have read all the briefs in this matter. I understand the arguments. I'm on top of this. What specifically thing would you like to highlight? And that's why you have your outline, right? You have your outline because, okay, this judge says that they know everything, that they've read everything, and they really understand the issues. Then I'm just going to hit the highlights or maybe a new case that I found and hand the judge that case, which brings me to another point. If you have cases, I like to put the cases up on the bench before the hearing and give a copy to opposing counsel before the hearing. But sometimes you don't want to give opposing counsel a copy so they're prepared for it. So you might just, if that's the case, then you wait. And then when you have a case, then you go and you give it to opposing counsel and you say, may I approach, Your Honor? Yes, you may. Here's the case I'm talking about. Make sure it's highlighted. Don't ever give a judge a non-highlighted case. And don't have a million highlights in it. Have the exact point highlighted that you want. And if the judge goes to start looking at it, stop talking until the judge is done. And then let the judge read what they're reading, and then they'll look back up and let you know that you can go ahead and start your argument again. So, that's kind of, it depends on if you want to put the case up there for them or not put the case up for them. But if the judge doesn't tell you that they've read the briefs or not read the briefs, then you kind of have to clue that in and say, Your Honor, as we've stated in our briefs, which I'm sure the court has read, this, and this, Sometimes I had a judge tell me one time, Mr. Zeta, don't assume that I've read your brief. And that's his way of saying, I haven't read your brief. Boom, you go back to full outline mode. You look at what kind of time you have, and now you have to be a lot wider or broader in what you're arguing, because you've got to educate that judge from square one. Once you're getting with a judge, I think you really need to know how that judge takes an argument or how that judge does a trial. Different judges are way different in the way they handle arguments. Some judges just like to ask questions, and they'll keep asking questions through the whole time. And those judges, you want to invite the questions. You want them to be questioning you. But there was a judge here in Tarrant County. She was rated consistently the best judge in Tarrant County. And what she would do is she would not ask any questions. What she would do is she would go ahead and tell the one attorney, go ahead and make your argument. And that attorney made their argument. And she'd say, okay, you've got 15 minutes. And then she'd say to the other attorney, you've got 15 minutes, make your argument. And she'd politely listen. And then she'd ask the first attorney, do you have any more arguments? And they would. And then she'd ask the second attorney, do you have any more arguments? And they would. And she would let them go back and forth until they ran the whole argument out. And that was her way. Her way was just to let them keep talking. And what happened in her case a lot was the lawyers themselves narrowed the issue through their arguments and made it easier for her to figure it out. She was also interesting in that she took all her opinions under advisement, virtually every one of them under advisement, unless there was a time crunch. And there's something to that. Smart judges will get a sense of, hey, someone's client's in the courtroom. We don't want to embarrass that client by ruling against the attorney in front of that client. I'm just going to go ahead and take it under advisement, and they'll send out an order the next day. A lot of times as an attorney, you feel really strongly about it when you're arguing it, and when a judge overrules you or sustains you or does the other thing to the other side and you lose, you're pretty angry at the moment. Angry is too strong a word. You're disappointed at the moment. But then when you're driving home and you're thinking about it, you're thinking, yeah, that probably was the right decision. And so by taking under advisement and then sending the order the next day, I don't know. I sometimes it takes a sting out of it if you don't win. Tip: never lie to a judge. There are times when you're going to go in front of a judge and you have screwed up, and you just have to say to that judge, "I messed up, and here's the law and how it prevents me from, or how it helps me when it mess up, or there's nothing really that can help me." But trying to stretch a fact or stretch an argument, taking a case and saying it what it doesn't say, or taking a fact and saying it what it's not really that fact. There's a difference between zealous arguing and flat out lying to a judge. And if you get a reputation among judges as a liar, they will tell the other judges, hey, this lawyer was in front of me today and just flat out lied. And if you get that reputation in the courtroom, in the courthouse, your credibility's gone. And so as an officer of the court, when you're up there arguing, you're arguing about not only this client, but all your other clients. Because if you screw up for everybody. Never interrupt a judge. I see young lawyers make that mistake, cringeworthy mistake, in front of a judge. The judge will start to make the point. Now the judge has sat there and listened to you for 10 minutes. And the judge has a question or a comment, and they get 3 words into it, and you're interrupting them. Yeah, that really makes judges mad. And I've been yelled at improperly in 30 some years. I can recall 3 times when I got yelled at when I didn't feel like I deserved it. And one was a judge had finished her question, or at least I thought she had, and I started to answer it. And she just blew up at me and said, never interrupt a judge. How long have you been practicing law? You've got to understand that. You've got to learn that. And I felt terrible. And so later she asked me a question, and I paused for like 5 seconds before I answered it. And I very politely said, I just want to make sure I'm not interrupting you, Your Honor. When we walked out of the courtroom, opposing counsel was very nice, and he said, I don't think you deserve that, Jim. And that particular judge got the lowest rating for judges in that county and got elected out of office the next time. So I didn't feel like it was just me. Other lawyers had problems with her. And so, but I felt terrible. I really felt bad when I did that. But it goes to never interrupt a judge. Know how much time you have when you're in front of a judge and what your argument is and how much time you have, whether it's on voir dire or on opening or on close, or if they're going to give you a time limit on the case that you have or a time limit on a hearing. And then also understand the judge's constraints. Maybe the judge is going to a luncheon and you have an 11:30 hearing, and that judge has got one eye out the door. So you've got to make your argument quick and understand what time you have. If you are arguing second, and this has happened to me several times in my career, when I am the respondent to a motion, and the other side will take 30 minutes, 35 minutes, 40 minutes, and the judge turns to you and says, okay, counsel, and you've got pages you want to respond to because you can win this thing. You know that they're wrong. And the judge says, you got 2 minutes to respond, Mr. Zeta. You got 5 minutes to respond, Mr. Zeta. And you feel horrible. You're like, why? He just argued or she just argued for 30 minutes or 40 minutes. So in my experience, when a judge does that, you've won. The judge has already made up their mind, and they're going to rule in your favor. And so you just be happy, that you're winning. I think if you come in front of a judge and the judge has a clock in the front of their courtroom that's facing you, like there's a judge here in Tarrant County that has a clock that's the first thing when he calls you to the bench. There's a huge clock right there. That's telling you he doesn't want to waste time. Don't waste his time. He's putting time up there in front because not to waste his time. And I know that from dealing with them. Another tip that I'm getting better at now, and I would say that I do it on my briefs a lot more. And I had a big case where an attorney came in to argue federal court, and I told him, you're missing something in your argument. He's like, what's that? I said, you're not asking for what you want. And so I said, it's really important, and I've been doing this probably for the last 10 years. My first statement is exactly what I want. Your Honor, I would ask that you grant our motion to compel and order them to answer interrogatories 3, 4, and 5 within 14 days, and I'd ask for $500 for preparation of this motion. And then you go and argue, and at the end of the hearing, you say, Your Honor, I would like you to grant my motion to compel and have them answer interrogatories 2, 3, and 4, and $500. You've got to make your exactly what you want the court to do when you're there. Another pro tip on that is always bring an order. Always bring an order. You're there in a hearing, you're there trying to get the judge to do something or deny something, and he or she does what you want and you don't have the order. You could walk out of that courtroom and end up not getting what you want because there's a delay in the judge getting it signed. You want it signed right there. May I approach? Give the order to the other side. May I approach the bench, Your Honor? And you go up and get that order signed right then. Always get an order signed right then. Now, a couple times I've had hearings where I've got what I wanted, but there's something going on where maybe another witness could have showed up or something else could have happened. I always, when I win those, I get my order and then I say, Judge, may I be excused? And the judge says, yes, you may. And then I hightail it out of there. I don't want to be in the courtroom when something changes and, oh, Your Honor, the witness just walked in. Can we have a second with the witness and come forward? Yeah, you don't want that to happen. So if you win, and you can, get out of there when you get out of there. I believe in outline, but I do not believe, especially in hearings, unless it's a major hearing, it's something that everybody's prepared for, but I don't believe in PowerPoints. I remember I had an argument. It was a pretty big argument, but there was a young lawyer on a big firm, and she came in with, I think it was a 60 PowerPoint presentation. And after about the 10th PowerPoint, the judge was just going crazy. The judge did not want to sit through a 60 PowerPoint presentation. And the lawyer ended up having to skip some of her slides. And as she was skipping her slides, she was losing her train of thought, losing her argument. And it turned out to be a very ineffective way of doing it. I was going to tell a couple of quick stories. The other day, I'm a co-counsel on a case with a person that I office share with. He's in charge of the case. I'm there just in case of emergency. I know very little about the case. And we got a phone call at the office, and it was a judge. It was a judge I know very well. She's an excellent judge. I've known her for years. And they said, I got a call from my staff saying it's the court coordinator in this case. So okay. And the court coordinator comes on and says, Mr. Zeta. And I said, yes. She said, you have a hearing right now. And it's a Zoom hearing. And opposing parties there, and the judge is there, and they're waiting for somebody. And the primary lawyer had health issues or a problem with, he had some health issues, which I was not aware of. And so I said, okay, but I didn't even know what case it was. And so she said, I'm going to patch you in. I said, just really before you patch me in, can you please tell me what case it is? And so we got on, and I asked my students, what would you do in that situation? And most of them said they'd ask for a continuance. But I knew this judge really well, and I thought it was just a motion to compel. And so I got on, and I was really at a disadvantage. I was on a telephone. She had them on Zoom, so she could see them. They could see her. I couldn't see anybody. And she said, but I was honest. I was transparent. Your Honor, my co-counsel who's in charge of this case, I don't know where he is right now. I imagine there's a good reason for it. I know nothing about this case, and I know nothing about what our argument is here today, Your Honor. And co-counsel, unfortunately, hadn't filed a response to their motion. She said, well, you all haven't filed a response, but that's not it. That's not dispositive. You can make your argument. And in the end of the day, I figured out what the issues were, and we were able to come to a resolution on the issues. And the court actually really appreciated that I didn't just try and bail, that I went ahead and tried to work through the issues based on my experience of having to deal with these. But that was a little nerve-wracking to have to do that. I had another case where a young attorney went in front of a very experienced judge, and that experienced judge was on a simple motion like an agreed scheduling order, and that judge started asking him really hard questions about the case, and the judge is actually a former partner of mine. And he came back and he said, man, that hearing went terrible. I said, why? And he said, well, the judge, I said, did you get your scheduling order? Well, yeah, we got our scheduling order. But what? Well, the judge, man, he was talking about this and talking about this and talking about this, and I didn't really quite know how to answer all those questions. And I said, he just did you a favor. And he said, why did he just do us a favor? I felt terrible coming out of that. I said, he just told you all the problems that we might have with our case in his eyes. And so now we've got to go and figure out the answers to those questions. You may not have felt it while you're getting grilled, but that really helped us. And truthfully, it did. There was a judge who made the big case. I think it was actually when Exxon bought a big oil and gas company that we have in here in Tarrant County, and there was a shareholder suit from the shareholders of the company that got bought saying it was an unfair transaction. And there were lawyers from all over the country that came in, and he said next day you all have to wear a college sweatshirt. And some of them wore a college sweatshirt to court, and some of them wore their suits. And he asked the ones wearing their suits, why are you wearing your suits? And they said, oh, we thought you were joking. He's like, no, I was serious. And so the next day they all came in wearing their college sweatshirts. That's the kind of judge he was. That particular judge also had a case in which when I had a bad case, I was a plaintiff's attorney, there was a motion for summary judgment. That motion for summary judgment, we were going to lose, and my case was going to get zeroed out. And the case just fell apart as it went on. And he came in, and they argued their summary judgment. I made my response, and he said, I think you all need to go talk about this case in the jury room. And so he was doing me a favor. He was signaling to me that he was going to grant the summary judgment, but maybe I should try and settle the case. And that was my goal, I had authority from the client to really take anything in that particular case. And so we went into the room, and as immediately as we went in the room, there was a young lawyer. She was the young female lawyer, and there was a supervising attorney who I thought was the client because he wore a golf shirt. And he was trying to help her during the argument, and the judge got frustrated with him, saying, let her argue. And I thought, well, the client was helping, but it was a partner. So the partner and we go into the jury room, and just as the door closed, she lights into me, starts calling me a liar. And I've been yelled at by opposing counsel, and I'm fine with that. But I said, I didn't lie about anything. I don't never lie in court, and I'm not lying about anything now. And she said, you lied about this and you lied about that. And I said, no, that's all on the record. That's not a lie. Those are all true statements. And And she said, well, I'm not going to, I said, the judge asked us to talk about settlement. I think we should try and resolve. I'm not going to pay anybody anything to a liar. I said, all right, well, this is not going anywhere. Let's go out and talk to the judge. So we got out there, and I said, Judge, we didn't make any progress because she called me a liar. And he said, well, Mr. Zeta, lawyers sometimes do that. And I said, Your Honor, I understand that. I've been doing this a long time. But she called me that 3 times and raised her voice while she was calling that. And he turned to her and said, you're calling Mr. Zeta a liar. You have to be very careful about that, counsel. What do you think he lied about? And she brought up a point I made, and she said, well, here's the opposite point in a deposition. And he turned to me, and I said, Your Honor, he said that sarcastically. I was at the deposition. She was at the deposition. When he made that statement sarcastically. I didn't lie. That doesn't contradict the facts in this case. He was just being sarcastic. And he turned to her and said, was that witness being sarcastic? And she said, yes, Your Honor, it was. And he said, you're not going to remember anything about this hearing except that you need to treat opposing counsel nicely. You cannot do that to opposing counsel. And I'm going to deny your motion for summary judgment. And that case did get settled, and that lawyer ultimately a couple weeks later didn't have a job. And then the other one I will tell you, just a quick story, is I got into a case in which there was an arbitration agreement when an employee got injured, and they wanted to take the case to arbitration and take it out of court. The first email I got from opposing counsel in the case was, if we don't agree to arbitration right now, that they were going to go in front of the court and ask for sanctions. And I wrote them back and said, that's not a very nice way to start a relationship between attorneys, threatening me with sanctions. I said, I think that there's problems with some arbitration agreements. Arbitration agreements have been overturned. I'm going to do my discovery, and I'm going to make my argument. And so we go in front of the judge after I did my discovery, and I had some arguments to make. And it was a young lawyer and another partner, and the young lawyer felt really confident that the hearing was going to go well. But I knew this particular judge, and I knew he wasn't really thrilled with arbitration clauses. And he was off the bench when we went up, and then as he walked in, he said, Mr. Zeta, why is this defendant trying to take away your client's Seventh Amendment right to a jury trial? I said, I don't know, Your Honor, but they sure messed up on this one. And it went downhill for them from there. And I do distinctly remember that young lawyer looking at me as the hearing was going on, like, please help me. And I obviously couldn't. And we were able to settle that case before it went up on appeal. So that's kind of my background with judges. I do want to give a few stories about judges behaving badly. There was a recent story here in Texas where a judge is handcuffing lawyers to the jury chairs. It happened twice with a judge where she ordered an attorney escorted to the jury box and had the bailiff handcuff the attorney to the jury chair. That's not good. A judge shouldn't do that. There was a judge out of Arkansas back in 2014, and he started... he got on an LSU, Louisiana State message board under the username GoJudge, Geaux, get it, Go Judge, and he contributed statements on that user board, including ballers just gamble like Arabs, drink like Indians, and do the Humpty Dumpty like rabbits. And then another one of his posts were, women look at 2 bulges on a man, one in the front of the pants, or second one in the back pocket, whichever one is bigger they can do without the other. And he went on, and no, judges shouldn't be doing that. There was another judge who failed to recuse himself from a child custody case when he was having sex with one of the parties, the mother in that child custody case, in his chambers. And he refused to recuse himself. He'd also sent a half-nude photo of himself to a court bailiff, and so got the nickname Shirtless Judge. And when he was confronted with that, he said, quote, "There's no shame in my game." And obviously he was suspended and then got removed from being a judge. There's one from Florida in 2014 where you've probably seen on YouTube, where a judge challenged a public defender to a fist fight, and that can't happen on camera, and then it goes off camera and they fight outside. The judge and the public defender have a big old fight. That's not so good. This is an interesting one out of Pennsylvania. Back in 2012, there was a judge who was found guilty of felony theft of services. And by that, what she did is she used her court staff on the court for doing campaign type things. And that's a no-no. You can't use your court staff for campaign. And she used it not only for her campaign, but for her sister's campaign. And she was found guilty and was put under house arrest and for 3 years, had to work at a soup kitchen. She was ordered to pay $55,000 in fines. But the interesting thing about this one was she was originally ordered to send an apology letter along with a photograph of herself in handcuffs to every judge in the state, and that's over 500 judges. She did have to ultimately send the apology letters, but not the picture of her in handcuffs. That was, I think, a little much. Whoever was doing that sentence was having a little bit of fun. So that's my tips on judges, and there's a little bit of stories of judges behaving badly. I hope you have a great week. Thank you. Bye.